Hello. Good morning, good afternoon, good evening, wherever you are watching us from. Welcome to today's edition of the SEDAT HR Digest, brought to you by SEDAT Consult. This is a continuation of the discussion we had with Senior on the termination. There were a lot of questions that, for the sake of time, we were not able to answer. So he was kind enough to say, okay, he will come back today to answer all our questions. So we have the questions from the last time we met with him. Those that were not able to answer, we'll go with those questions. And then you can ask your questions. Today is all about you and the questions you have. So we are not going to ask our own questions, but the questions that you have, after we have answered the questions from last time, we will invite your questions. So you can still drop your questions in the chat box so that we can answer them. So whilst we wait for Senior to join us, let me acknowledge those who are here with us on Zoom. We have Ikia Asante. Thank you, Ikia, for joining us. We have Augustine, Benjamin Techisam. Benjamin, thank you for joining us. We have, let me go through the roll call. We have Rita, Mabel, Sam, Idris, Paul. Thank you, Paul. Paul, it's been a while. I hope you are fine. We have Rita, we have Samuel, we have own boss, okay, my boss and your boss. Senior is here. Thank you so much, everyone, for joining us. We are also streaming live on all our social media platforms, on YouTube, on Facebook, on LinkedIn. So please, your questions are welcome, but I'm going to start with the questions we had from last time so that we exhaust those questions and we come to today's questions. Thank you, everyone, for joining us. And share the link and let your colleagues also join us. You know how important this discussion is, and it's been very beneficial to all of us. So thank you so much for joining us. Let me take this opportunity before I go into the questions to welcome. Senior needs no introduction. I mean, for those who have encountered him, who were here the last time, you know, but when it comes to labor relations, he's an expert. For me, from the experience I have with him, I think he's my go-to person, and I know some of you know him. And like we said the last time, if you have any questions regarding labor, union relation, whatever you want to do, he's your person. And he shared his number with us the last time. And in case you didn't get that, I'm sure he'll drop in the comment section or say it again before we leave, so you can contact him. Because labor law, yes, the laws are there, but sometimes interpretation becomes challenging. So if you have an expert like this, you want to really make sure you are in touch with him to ensure that you are covered, that you don't fall foul to the law. So thank you. Let me also introduce our upcoming training on compensation and benefits management. It's coming on the 25th and the 26th of this month. It's very practical, hands-on. We will take you through how to conduct a job evaluation practically, and then build your own salary structure that will work, that you can explain. That will be very, very, that will have equity, both internal and external. So welcome. Right, I don't want to talk too much because there are a lot of questions that have come in that we need to respond to. So Senior, please, welcome. If you are here, you can hear me, kindly say hi. Is it possible to turn on your video as well? Hello, Senior. Hello. I guess Senior is out, but I'm sure he'll join us very soon. Okay. Ophelia, you're welcome. Thank you for joining us. Ganui, thank you for joining us. Habuza, okay. Thank you for joining us. Vincent, thank you for joining us. Senior, please, can you say hi? Let me know you're around. Is it possible to turn on your video? Okay, I think Senior is still connecting his audio. Let me notify him. He needs to connect his audio. Just a moment. Okay, Senor is on now. Hello, Senor. Thank you so much for accepting to do this again and to help us answer all the questions we had from the last time that we couldn't respond. If you can hear me, hello, Senor.
Yeah, hi.
Okay.
You can hear me now?
Yes, I can hear you now. Thank you so much. Right, so go ahead, Senor.
Yeah, go ahead.
I want to go straight.
I was just going to say good afternoon to everybody. Is it 4 o'clock good evening or good afternoon? And
I do good afternoon, but there are people joining from all over the world, so it's fine.
Do I look dark?
A bit.
Okay, let me do something. Let me give myself a bit more light.
All right, that's fine. And please kindly mute. If you are not talking, kindly mute. After the questions are exhausted, you want to ask the question, then you can unmute. So kindly mute so that we limit the interference.
Yes, please, I've muted it. Yes, I've muted it. I've muted it, please, madam.
Okay, but we can hear you talking, so it means that it's not muted.
Yes, I've muted it.
All right. Okay, thank you. Right, so let's just zoom into the questions. There are a lot of questions. So from the last time, this one is from Kweku Yeboah. He says, how do you treat a situation where a staff vacates post since it's a form of termination? Senor?
Yeah, how do you come again with a question?
How do you treat a situation where a staff vacates post since it's a form of, I think he's asking a question, is it a form of termination because there's a question mark?
I think this one, we answered it last week, that vacation of post, yes, is a type of termination, but that termination is normally on the instance of the employee. So it's the employee who decides to show up to work for, if the policy says 5 days without, authorization or notification to the employer, or if, like in the public sector, it is 10 days, then the employee has, by their action, sought to terminate the employment, and hence the employer just comes in with a document to, like a letter or a communication to confirm that, hey, by virtue of your not coming to work for so many days, we confirm that your employment is terminated. And that is actually due to the action of the employee. However, there's a caveat. The employer has to be able to prove, if challenged, they should be able to prove that they sought to know the whereabouts of the employee. The employee chose willingly to absent themselves or to abstain from attending work, and that it was not due to any circumstances outside of the control of the employee. That would make the employer a savage employer, right? So HR has to normally go the extra mile, locate the employee, ensure that there's nothing wrong with the employee, but it is the employee's own choice to abandon their job, and then they can terminate on the basis of vacation of post, yes.
Right, thank you. So you can't just say the person has absented themselves from work, so that is it, I won't do anything. As HR, we need to go the extra mile to find out why. For example, if the person was involved in an accident or that something like that. That's why I think we take next of kin, Senor. So that at least if you can't reach the employee, you can reach the next of kin to find out if everything is okay.
Yes. But remember, at law, next of kin is not a beneficiary. So those who have been giving people's money to next of kin, now that you've mentioned it, let me just remind everybody.
Sure, go
next
ahead.
of kin is in case of emergency, who do I contact? You know, next of kin is who can I contact other than yourself or your family or whoever. Next of kin could be anybody, but next of kin is not a beneficiary. So if somebody dies or leaves the job or something, you can't find the person. So pay the check to the next of kin. Legally, you may be in trouble.
Okay. Right. I think today's Senyor's internet is not helping. You are back. Thank you, Senor.
Yeah.
You can go on.
So next of kin is not a beneficiary. Okay, maybe we can go on. Sorry
Yes,
for the short interruption. Was it me or it was you?
I think it was you left,
All right,
but we
can
can't go
go
your
on.
back. Okay. Please, can everyone hear us clearly? It seems happy. You are saying the volume is low. I have the highest of the volumes. Can everyone hear us clearly, please?
Yes, please.
All right. Thank you very much, Simon. Right. So the next question is from Zachary Salamat. She says, can an employer terminate employee based on excessive late coming?
Yes, but there are a number of issues to keep in mind. For you to terminate an employee on any ground, that ground needs to be something that the employee knows about and has been informed about. You see, you cannot make rules, keep them in your cupboard, and then when somebody infringes, you bring it out and say that you've infringed this rule. Person needs to know that it's an offense. So you need to state in your disciplinary code, especially the schedule of offenses, absenteeism and the penalty for absenteeism. That is the first one. Then you are legally then, right, or you have the right legally then to be able to terminate on the basis of that offense. And let me make this general statement that unless generally accepted as practice, any offense that you terminate for must be in your schedule of offenses. So you must point to something that says that in your policy it is an offense, because we have different cultures, we have different organizations, we have different practices. So if in your organization something is an offense and you don't state it, then out of the blue you come and say that it's an offense. That could be a problem. So you need to state first that absenteeism is an offense and it is, I don't want to use the word punishable. The penalty for that particular offense is, say, progressive discipline. So verbal warning or final warning and termination. So once that is done, you have the foundation to be able to terminate on the basis of absenteeism. Let me finally say this, that you cannot deduct money, okay, from employee salaries because they are absent, especially if they are salaried workers. If they are permanent salaried workers, if they are temporary workers, casual workers who are marked by day, that's a different ballgame. But if it's a salaried worker, you cannot keep the person's pay or withdraw money. You say that 1 hour you are not at work, or this day you are not at work, so I'm not paying you for today. It doesn't work. The right approach to dealing with, or the legally acceptable approach to dealing with absenteeism is through discipline. And people should be able to be terminated for absenteeism, because absenteeism is a contractual matter. You have to attend work, do the work, and get paid for it. So if I keep paying you and you don't keep showing up, then it means that you are breaching your contract of employment. You may not be interested. So absenteeism has been, whittled down and taken for granted in these parts of the world. I don't know why, but it's a big deal. Once I computed number of hours per month for lateness and absence, and when I computed it and commuted it to cash, it was so much money the company was losing. So absenteeism is a ground for termination, but you need to go through the necessary disciplinary process and then you terminate legitimately.
Well,
Yeah.
thank you so much. Let me stress this. Senior has said it, and let me stress it for the sake of those who may have just joined, that you should have it in your schedule of offenses. Okay, so you can't just bring it out and say you have fallen foul to this and you are terminating when it is not in your schedule. Because if you are challenged, you have to refer to your schedule of offenses, which will be part of your policy. Thank you, Senor. Educhum Ajiman is asking, what happens if an employee is found to have caused financial loss to the organization and such employee's appointment is terminated? Is the employer obliged to commute such employee's outstanding leave and pay in cash when the employee is exiting?
Please read this again. Okay. Yes, please.
What happens if an employee is found to have caused financial loss to the organization and such employee's appointment is terminated? That's the first part of the question. And the second part is the employer obliged to commute such employees' outstanding leave and pay in cash when the employee is exiting?
Well, when an employee causes financial loss, that financial loss would be determined by, no, let me put it this way. The employer's action, assuming they want to terminate, will be dependent on whether that financial loss results in an offense or not. So he's caused the financial loss. Is it an offense or is it not an offense? If it's an offense and that offense is penalized by termination, then the person can be terminated. Indeed, I mean, if financial loss occurs, it is easy to imply and also prove in a disciplinary committee process or in a disciplinary process that the employee might have been negligent, might have been, you can prove it as an offense. If it is an offense, then you can terminate. Now, you know that it is practice that during termination, there is an exit account which is done. The exit account would normally compute all the monies that are due the employee versus the money that the employee owes the company. So if it is proven properly, and that is why in such kinds of termination, there has to be a proper disciplinary process that establishes the exact amount and pronounces on it, so that it is not like, so there's a good investigation, that investigative report results in a disciplinary action, that is the queries and all that, the person appears and the person is taken through the proper process of being heard, and then the amount that is leading to the termination is determined. This is what accounts of finance will pick as monies owing to the company. Now, again, the disciplinary committee must recommend necessarily that the money should be paid back. Okay, so if the disciplinary committee during recommending the termination, it does not indicate that the money should be paid back, then who is asking that the money should be paid back? And on what authority is the person saying the money should be paid back? The best way to do this is that the disciplinary committee pronounces on the issue that the employee has been negligent, or the employee has not done their duty, or the employee has colluded with somebody, leading to losses to the organization to this tune. And therefore, the money should be, the company should do all it can to retrieve the money. Then accounts can take that termination recommendation or termination decision and pronounce on it and use that to do the exit balance, okay, exit account. And so they will balance it against, and the person asks about leave. Leave owed legitimately to the employee, or the employee's outstanding leave, is always committed to cash during termination, except when it's a dismissal. Okay, so Section 33 of the Labor Act says that except for dismissal, the employee is entitled to their leave committed to cash. Okay, so the leave will be committed to cash if it is termination. If it's dismissal, you know that the employee forfeits everything. So yes, this is generally what I can say about the issue of financial loss maybe leading to termination, and whether leave committed to cash can be done or not. If it's termination, yes. If it's dismissal, so depending on what you choose to do. If you dismiss the employee, no, it's not entitled. If you terminate the employee, then they will be entitled. But you would put all of that together with the employee's total earnings up to the date of termination, and you knock it against the money you say they are owing and any other monies, that is the liabilities, and then you come to a general figure to show whether employee owes something or not. Then if they owe, they are written to accordingly in their termination letter, and efforts are made to recover the money, however the company wants to do it. Yeah.
Thank you very much. This is very instructive. Edichum, I hope your question has been answered. Emmanuel, your hand is up, but if it's we need clarification on something, a question that Senior has already answered, then you can. Otherwise, kindly drop your questions or hold on to your question. When I'm done with the questions that I have here, then I can ask your question. So, Emmanuel, let me know if your question refers to something that Senior has said already that you need clarification on.
Okay, madam. So, subject to what he just said, supposing an employee is executing his duty, and in the course of that, he caused damage to the company property. So, in that instance, can they be that the employee need to be terminated, or the cost of damage can be calculated and charged against the employee?
Right, thank you.
Good.
Senior.
So the cost, yes, so the cost of damage can be calculated and charged to the employee, and that would be a permitted deduction, because Section 70 of the law on permitted deduction allows for withholding of an employee's pay or deduction from an employee's pay, any damage or loss that occurs. But the key thing to do here is that there has to be proper investigation to determine that the loss was actually the fault of the employee. You know, sometimes some losses are normal. In the normal course of work, certain things are bound to happen. If the employee can prove, or it is evident that the employee could not have saved the situation, and it was a damage beyond the employee's control, then of course it will be unfair for the employee to be charged with the damage. But if it is clear negligence, that the employee did not follow safety regulations put in place to prevent any such, damages, and then they breach the safety rules and result in this kind of damage, then, and of course, it's a safety matter, and safety matters are important matters that always have to be dealt with. So yes, it may lead to termination, or it may lead to the employee being surcharged with the cost of the financial loss. Yes.
Thank you very much, Senor.
Okay,
so thank you, Emmanuel. Another question from Edichum says, can employee of job A and later reassigned to job B appoint? Okay, so the person was employed for job A and later he was reassigned for job B. The question is, can this employee be terminated for non-performance since he applied for job A and not job B? I don't know whether you got it.
Oh, yes, I get it. So employee was employed for job A and was transferred to job B, and then did not perform in job B, so they ended up being terminated. Yes, it's legitimate. You accepted job B. You accepted to do job B when they put you there. If there's any evidence that you complained and you sent a complaint, an official complaint, that you didn't have the skills for which you had been given job B, and management did not offer you any training, did not offer you any coaching, did not offer any assistance to equip you for doing job B, then of course it will be unfair termination, because it will be seen as setting you up to terminate you. They put you in a place where you had no skills, no competencies, and therefore, having not performed, they still terminated your employment. That would be unfair. But if you accepted it and you didn't complain, and it seemed everything is fine, and when you were doing the job and you were finding difficulties, you didn't put anything on record, and performance management comes and you did not perform, so certainly they put you through PIP and all other support programs and applications, and you still did not perform and you are terminated. You can't now go back and come and say that, oh, well, I was put into job B and I wasn't good at job B, and my termination is unfair. No. You, by commission, you accepted to do job B. And if it had gone well and it had earned you a promotion, you would have taken it. You would not have complained. So yeah, right. Both ways work. So yeah, that's what I, yeah.
All right, thank you. So please let us all be advised. I mean, sometimes I think the demeanor we portray at job is as if the employer is doing us a favor, and so even if you have a challenge, we don't say it, or for fear of losing our jobs and all that. Please, it's a relationship, okay? You give something and then you get something. So see it as that. And if you have a challenge, be open and go ahead the proper way though, and get answers. If you keep quiet and then later you are terminated and now you come up, then it's going to be a problem. So please, respectfully, but let's make our points known or our grievances known through the proper channel. Thank you very much, Senor, for that. Okay, right. There's a question in the chat, but let me finish with this one. Voice Inspire, that's the name. He says, is it legal to reduce an employee's salary because you reduced their responsibilities?
No, it's not acceptable. You chose to reduce their responsibilities. The thing is that, you see, on the duties of an employer, one of the key duties of the employer is to pay remuneration at the place agreed and the amount, you see. So if it is contractual, it is only the two parties who can now vary the contractual provision. So if you've told me that I've given you this work and I'm going to pay you 5,000 as net, and it is in our agreement and we've both signed and we are going, if you come and reduce my responsibilities, you can't then now automatically do that unless I agree and we amend. Okay, so you send me, what do you call it? You send me like a memo and I acknowledge, then it works. But if at the end of the month, my salary has reduced, and when I ask you, say, oh, but I reduced your duties, and so I have reduced your pay. No, that is not acceptable. That is very, very bad faith. It's an action in bad faith. So we need to communicate and we need to agree. Anything that is in the contract, if we are going to vary it, that is why the unions will tell you that an employee cannot be made worse off. And when you ask them where it is found in the law, they will tell you that no, it's an ILO convention. But no, it is a contractual principle that an employee cannot be made worse off because all the things that you've chosen to pay the employee are agreed or by convention have been agreed. If it's not in the contract and you start giving me some money every month and you tell me that, oh, it's because it is acknowledgement of hard work, okay, and then in my mind, that has become part of my remuneration and it's not one-off. So you pay it on a monthly basis for more than a reasonable time. You are coming to remove it. I'll tell you that no, this is a convention. It's become an agreement. it will make me worse off if you take it off. So the things we decide to pay employees, we need to be careful. But the only way we can change anything in an employee's contract is by agreeing with them. You do a short memo, you do a letter, they sign as an acknowledgement, you are covered. Otherwise, it is a breach of the contract and you can't justify it anyway. Yeah.
Right, so let's be advised on that. Thank you so much. Rhoda Boachian's question: Can an employee's contract be terminated for lying that he or she is not engaged in any employment elsewhere, especially a competitor? So the employee lied that he's not engaged, but later you found out that he was engaged and also with your competitor. Can the employment be terminated?
Good. So the first thing again is lying an offense in the company? Okay. Is lying an offense? If lying is not an offense in the schedule of offenses, then it's very difficult to terminate on that ground, unless you have a shrewd and a very knowledgeable disciplinary committee chair who is able to craft his reports, his disciplinary committee recommendations in a way that kind of weaves the offense into the values of the company. Because every company has values, every company has a culture, every company has all those things, that ethics and all those. So he's able to, so even though it is not in the schedule of offenses, the disciplinary policy, he can still weave it against the values. Another thing he can do is to also weave it into the duties of an employee under the Labor Act. I think it is Section 10, right? Duties of an employee. So no, duties of employee is Section 11. So yeah, you find a lot of things there that an employee must do. If the employee cannot do those things, then the employee is in breach of their contract of employment, because it is their duty so to do in accordance with law. Okay, so if it's not in your policy, you can look for it in Section 11 of the Labor Act. And those things there, maybe you can weave it into it, or you can use the values of the organization and the belief systems, the practices of the organization, and weave it in and make it something unacceptable, which is serious enough to warrant a termination of employment. Because anytime you terminate, we would ask whether you were reasonable or not. First, whether you were lawful, whether you were fair, and fairness also goes with reasonability. So whether your decision was reasonable, it was not harsh, and things like that. Now, lying and dishonesty is a huge issue. It cannot be something that should be tolerated in a workplace, and therefore must necessarily lead to termination. In my principles of practicing HR, if you are dishonest, you are out. You know, if you are honest, you are in. And so if you are dishonest in any way, or you conduct any criminal activity, you are out. Like you steal, you do all those things, you are out. So we need to strengthen our ethics and make sure that we only keep employees who are loyal, who are competent, and also who are willing to die a little bit for the organization. Yeah. I don't know if I've answered the question, but sometimes I tend to talk too much.
No, it's good.
Yeah.
You are giving us insights, because you know, if we were to come to you as consulting you, and we know we can't. So thank you. We want to get everything out of it, but we will still come. Thank you very much for that. Stephanie Danso, and that's the last question I have from last time. So if you have your questions now, you can drop them in the comment section, and then I'll pick it up from there. Stephanie Danso is asking, what do you tend to lose during dismissal process? I don't know. I think, well, maybe you get the question. What do you tend to lose during dismissal process?
What do you tend to lose during dismissal processes? Basically, you lose everything except your salary that you've earned up to the last day of your employment. You lose everything. Even if there's PF, it is only most PF rules will pay you only your side of contribution. They will not pay you the employer side. So if you get dismissed, and that is normally for very serious offenses, you will be dismissed. If you are dismissed, then you lose everything. That is what I meant to say. Yes, you lose everything. Okay, you forfeit everything. Yeah.
Right. Thank you. So let me go to the comment section and begin to look at some of the questions. If you have just joined us, this is SEDAT HR Digest, brought to you by SEDAT Consult. And we are privileged once again to have Senor helping us understand terminations and dismissals, what we need to know, what we need to do, and how to, like they say, cover our backs so that we don't fall foul to the laws. Right. Just a moment. I see your hand, Simon. I will get back to you, but let me pick this question. I'm trying to pull out the question in a moment. Okay. Okay, so no, this one is from us. Okay, sorry about that. One more. Please, if you've not registered for upcoming compensation and benefits, the link is in the comment section. Just click on it. Okay, this one says learning a lot. I think I'm missing the first point. Okay, just a moment. Can one terminate? So can you see from your side? I'm trying to locate it, but it seems I'm...
Yes, I can see Joseph Sam is asking, great presentation. I'm learning a lot. Please, can you explain the difference between dismissal and summary dismissal? What is the obligation of the employer in the event of dismissal and summary dismissal? Second, under what circumstance can an employer reject the resignation of a staff who tenders in the resignation letter? Finally, what is your opinion on resignation of staff with immediate effect? Okay, resignation of staff with immediate effect is their right. And often there is a clause in the contract that says if they fail to give notice, you withhold 1 month, okay, of their salary. If you don't have any kind of contributory program like a PF or anything, and the employees don't have any money with you, then they go scot-free. It's very difficult to take the money back. But if you have a PF, you can always withhold the 1 month from there, and then the employee can go. Can an employer reject an employee's resignation? No. Under what circumstances can they reject? They can only hold it for a while, especially if the employee has an ongoing disciplinary matter. Now, if there's an ongoing disciplinary matter and the employee is before a disciplinary committee and they tender in their resignation, an employer has the right to say that let us complete the disciplinary process, and then your resignation can take effect, or your exit can be determined appropriately. But if there's nothing, an employer cannot reject an employee from an employee's resignation. This is where the law stands. There's no forced labor in Ghana. Forced labor is abhorred by the Labor Act. So because there's no forced labor, an employee says, I'm leaving. You cannot say by force, I will not let you go and that you have to work for me. That becomes slavery. So there's no way that an employer can decide that they are not accepting the resignation of an employee. There are so many cases that the courts have held that the employer cannot stop an employee from leaving, unfortunately. Dismissal and summary dismissal. Remember, in fact, the Supreme Court has made a very fine distinction between dismissal and termination and all other forms of exit very nicely in the case of Akpas versus GCB. I always refer to this case because it seems to have dealt with termination on all of the levels. Okay, so it's dealt with the issue of what dismissal constitutes and what termination constitutes. Termination is where the employee leaves on the basis that both parties have agreed that, like mutual termination. So then they get all their earnings and some other benefits, they get it. Dismissal is an involuntary exit where the employer is terminating the employee on the basis of a serious breach or misconduct or something. And that is seen as serious, which normally is even a threat to the very existence of the business. And that dismissal is so critical that it is terminated without notice. Of course, termination is with notice because of its mutually agreed. But in dismissal, there's no notice, and the employee, as I've said, loses everything. They forfeit every benefit. Good. Now, what then is summary dismissal? Summary dismissal is just a creation of policy. Summary dismissal is not in our labor law. Summary dismissal is not in our labor law. So where you want to use the word summary dismissal, you will need to put it in your policy. If it is not in your policy, then summary dismissal becomes alien. So you cannot summarily dismiss somebody if it is not in your policy, it's not in your disciplinary code, it is nowhere. Because that creation or that phraseology is not in the labor law. It's not it's not acknowledged by the labor law, or it's not seen, recognized. I'm struggling with this English. It's not recognized. It's not recognized by the labor law. Okay, so when you want to use summary dismissal, then it should be well defined and well outlined in your in either the contract of employment or at best in your policies. Okay. So Joseph Sam, I don't know whether Joseph Sam is my friend though. I don't know whether I've answered all your. I think I've answered all your questions.
Okay,
a lot
right.
Of people
so
are
the next one. Oh yes, I know you have a lot of. They are here to listen to you because they can't, just stop listening to you. Rita is asking, can one terminate an employee's employment after probation based on absenteeism during the probation period? What should be the process?
So during probation period, the person is being absent, but the person is not terminated. It is only after probation that they decide that they will terminate on the basis of absenteeism. Well, after probation, if the probation expires, okay, if I don't know what they mean by after probation, if the person has already been confirmed, then you cannot now go and use an old accusation or an old occurrence against the person. That would be unfair. If the employee has, after probation, the employee has been confirmed, they've given the employee their confirmation letter, they are now properly so employees, then you have to now start over and get the person to commit the offenses, and then you deal with them accordingly. But if it is a probationary assessment that codifies and records all the number of times the employee has been absent, and they put it together and they say that well, you are found to always be absent. And on those bases, we cannot continue with the employment relationship, and therefore we will not confirm your employment, and hence we are terminating. Then it's fair. Because like last week I said, oh, it wasn't last week. I keep saying last week. It was last week. Yes, I did say that probation is a trial period. So if during the trial period, we have realized that, okay, over the 6 months or over the 3 months, you've been absent 24 times or 6 times or 10 times or reasonable amounts of time, and you've not given any cogent response to any questions, or you've not given any acceptable reasons, then of course, if we say we are terminating and we are not going to approve your employment or confirm your employment, I think it is fair. So yeah, it is doable, but the way it is done is what will determine whether it's fair or not, and which part of the divide it is done, whether after confirmation or before confirmation of employment after probation. Yeah.
Thank you very much. Simon, you can unmute and ask your question. Simon, if you can hear me, kindly unmute and ask your question. Then I'll go back to the chat.
Before Simon comes, there's a question still on termination, interdiction.
Okay, from Bismarck. Is it the one from Bismarck? Yes. Okay, yes. All right. So you want to answer that? Okay, so Simon, please hold on.
Yes, I think because
this is a follow-up. Yeah.
All right, thank you.
Okay, so Bismarck is asking termination, indefinite suspension, dismissal. Which of the above will be most suitable legally for a staff who absented themselves months and more without permission or without any reason? Do I get it? I think some are hidden.
2 months and more without permission, and even engage in partisan politics.
Hey.
Well, it depends on what your policy. If your disciplinary policy, you see, every offense is supposed to be put on a particular scale in line with the priorities of the organization. Okay, so more severe offenses would be put under, say, very serious offenses, and then others will be put under general offenses, and so on and so forth. So the schedule of offenses needs to classify the weight of offenses. So if the offense is weighty, then of course you will do either your dismissal and so on and so forth. But let me just say here that, you see, the word indefinite suspension, it scares me. It scares me. It makes my heart beat. There's nothing like indefinite suspension. Indeed, in the practice of the word indefinite suspension, it is an unlawful action, because you can't suspend somebody indefinitely.
Forever.
And indeed, look, suspension can only be for a term, because the word means suspension from duty for a period. But you cannot say indefinite suspension. Indefinite suspension means that what? The contract is terminated, or the person is still an employee but is not allowed to come to work. No, it's technically problematic when we look at how our laws are structured. So indefinite suspension, no. So we have suspension, okay? But of course, I'm sure by now we all know that suspension without pay is unlawful. So suspension without pay is also unlawful. Indefinite suspension is unlawful. So we have only suspension, and then we have demotion. Suspension is for corrective purposes, where the person is removed from their day-to-day work. They are taken to be trained, to be corrected, to be coached, and then they are returned to their duty. That is suspension. Suspension does not mean the person does not have to come to work, but you can demote. In your disciplinary schedule of offenses, you can demote a person. You can demote for a period. You can demote indefinitely. And when you demote indefinitely, the person now drops into a lower grade, and then it continues from there, where the person now has to fight for promotion to rise again. And in the banks, we used to have a phrase, we say, an officer, an employee or a person's behavior or action is unbecoming of an officer of the bank. So if your behavior and performance is unbecoming of an officer of a bank, then we will drop you to a lower position where you now relearn, and then you can rise again and become a proper officer of the bank. So this is what I have to say about suspension and its, funny legal implications. Yes. Okay.
Thank you so much. We are learning.
Simon
Yes, Simon, please go ahead.
Yeah.
Go ahead and ask your question before I come to Dolores in the comment section.
Okay. All right. Thank you very much. I think I'm learning a lot. And on the issue of deductions, I think between the employer and then the employee has a duty, and then the employer also has a duty. And one of them is the employee has the responsibility to work, and then the employer also has a duty to pay the employee. So
That's
in
right.
the case, yes, in the case where the employee is not always at post, let's say when you come to the public sector, they will tell you that when you just absent yourself from duty without permission for 10 working days, it is deemed to have vacated you. It is deemed that you have vacated your post. But where the person will come to work, let's say 8 days, 9 days, he has been warned severally, progressively he has been disciplined, let's say verbal warning, written warning, and he's still doing it. Is it not right for the employee to say that, okay, fine, if this month you don't come to work, okay, I'm going to deduct the number of days that you are going to absent from duty from your salary?
No. What is stopping you from terminating the person?
Exactly.
If the person has breached the contract of employment, what is preventing you from terminating the contract? Why do we run away from enforcing the terms of the contract of employment, and we try to use all manner of, I'll use the word, inhumane means of just trying to punish people? Okay, so once you take the money from his salary, then he knows that after all, if I'm late, it's only money they'll take from my salary. But the law is saying in section 69 that you cannot impose a pecuniary penalty, a financial penalty on an employee for any reason whatsoever, except what is permitted law, or where another law approves it. So there's no way you can use discipline to withhold somebody's pay. Then it means you are failing to discipline the employee. And if you are failing to discipline the employee, you cannot use a financial penalty to discipline an employee. It's not allowed. The law does not allow you to touch employees. See, there's a case, a high court case, where the judge actually even said that the employee's salary is his property. So it cannot be, it cannot be coveted by the employer. You know what covetousness means?
Yeah.
Property without, and even in those who are Christians, in the 10 Commandments, they do not covet your neighbor's what? It is such a serious principle in law that where it is somebody's property, you don't touch it. And the courts have said that the salary you pay to the person is earned. It is his property. So you can't touch it under any reason whatsoever, unless it is permitted or unless it is with the consent of the employee. So when you have pre-agreed that, we have a loan, I'll take it, or there's a PF, I'll deduct, or I'll do this, I'll do that. Yes, but you cannot just say that because I'm late, you are taking it from my salary. The law does not allow it. Terminate the person.
Okay.
Yeah. Or demote
Okay.
the person.
Right.
Or use any
Okay.
other penalty that will go the person, but don't touch the person's salary.
Salary. But
Thank you very much for that question, Simon. And we are
thank you.
learning.
Yeah.
Okay, so we have Dolores says, thanks for your presentation. I'd like to ask how an employer can determine which case merits dismissal or termination, particularly if it is not stated in the company's policy.
Okay, how does an employer determine? Basically, it will be based on the values, right, of the company. So when you are crafting your disciplinary policy, you know what the company will accept and what the company will not accept. I mean, so it has to be classified. There are some disciplinary policies I've seen, and I see the schedule of offenses, and certain very serious offenses are put under, like normal offenses. But you have, very serious offenses. You have some very trivial things in the serious offenses. You need to classify your offenses properly and give them weight. What is acceptable, what is really, really critically non-acceptable, and so on and so forth. Give them weight, and then put the very weighty ones in the serious offenses category. Those ones would merit dismissal where the person is found culpable. And then the rest, you can do your warnings and final warnings and suspensions and possibly demotions and things like that. But you need to determine it yourself according to your policy. Nobody can tell you what you should do in your own organization. So you need to put it in a policy, and then you can enforce it. Yes. Okay.
Thank you very much. Wow, we have just 2 minutes, but I think we have about 8 questions. So now I'll quickly run through.
Okay.
My role, Catherine is asking, my role as an administrative manager was changed to a customer service coordinator. And my reporting line also changed from reporting to, okay. So now, can you see what I'm reading? I think that some of the words are hidden from my end. Also changed from, it's from Catherine Eshen.
Okay. Let me go down. Hey, I can't see it though.
Okay, so reporting line also changed from reporting to, I think, the customer service to the HR manager. Hey, Charlie, let me see what I can do. Just a moment. I'm trying to see if I can expand that. Okay. So reporting line has also changed from reporting to the, I still can't seem to find it. To the HR manager, but salary remained the same. I want to know if it is right to report to a colleague on the same level. So he was an administrative manager and then later reassigned to customer service coordinator and then was made to report to the HR manager, but the salary remained the same. So she wants to know, is it right to report to a colleague on the same level?
Well, these are administrative structural issues. If your salary remains the same, then there's no problem. If you can be asked to do a number of things in an organization, if they do not reduce your salary, then they've not breached your contract. But let me say this, that You know, the things that normally as HR people we call transfers is sometimes a very dangerous thing to do, because you can only transfer a person from one location to the other, but the same job title, the same job duties, right? But if you are moving the person to another job with another job title, you cannot treat it as a transfer. You need to treat it as a change of designation, okay?
Or reassignment.
Or reassignment. And reassignment, change of designation, would mean that you are varying the initial terms of the contract, and you need to get acknowledgement from the person. Then you are safe. But you cannot use the word transfer and move the person from HR to operations or to customer service or to something else, which is not the same job title on the person's contract of employment. We need to really, really be careful about this. But for me, because of internal job rotation programs and other forms of employee development, there are so many things that can lead to reorganization of roles in an organization or in a company. When that happens, you are still earning what you are earning, there's no problem. But when it is reduced, when they are saying that by virtue of where they are transferring you to, you are not entitled to some of the things you were earning before, then you have suffered diminution, and that becomes a demotion, and therefore it becomes an unfair practice and a breach of the contract of employment and also the labor laws. Then there's a problem. So I think this is what I can say about this. Yeah.
Thank you very much. Simon, I see you. I'll come to you, but this is also from Dolores. If an employee turns in the resignation and the employer persuades the employee to stay, would you advise the employee to stay or quit? It's on your personal opinion. What advice will you give as a labor expert?
If an employee turns in the resignation and the employer persuades the employee to stay, would you advise the employee to stay? What led to the employee wanting to leave? If the employer is correcting what they complained about and what was causing them to leave, then maybe you want to stay. But I'll tell you my personal views. If you are an employee and you turned in a resignation, you say you want to leave, I'll start looking at you as an employee I can't trust. Some employers who are very savage would accept will convince you to stay and now try to get the things that normally they thought they would lose. Maybe they would let somebody understudy you, or certain information you had, they'll find a way of having it. Once they have those things, they can let you go and they can terminate you. So you need to be very careful when you want to tell an employee that you are leaving. And when you are leaving, you need to be sure that you are leaving. And when the employee convinces you to stay, you should know that once you stay, then you have become someone who is not seen to be loyal. So anything can happen, and the employer can do anything. You will not be trusted again. That's what I'm trying to say. Or the level of trust the employer had in you would reduce. So you need to weigh your environment very carefully, know who your bosses are, and then there are certain employees, everything I'm leaving, everything I'll leave, everything I'm leaving. Like some women in marriage. I'll leave you.
I know you're going to say some men in marriage.
I'll leave you. And then by the time you say you are actually leaving, the person is used to it and has psychologically built up a defense and put things in place that would make them be able to survive without you. So it is normally not a good practice to always be sending in your resignation if you are not absolutely, certain you want to leave. Okay. Yeah.
Thank you very much. Ophelia is asking, please, can we have a recording of this webinar afterwards? Yes, it will be on our social media pages. So please follow all our social media pages, SEDAT Consult Limited on LinkedIn, on Facebook, and then on Instagram, and then on YouTube, it's SEDAT HR Digest, right? Thank you very much. Simon, you can go ahead and ask your question. Simon Mensah. Sometimes I don't know whether it's Simon or Simon. Okay. Please, which is which? Okay.
Any of them goes.
All right. So can you ask your question?
All right. So I just wanted to if you like, provide some explanation to the person who asked the question with regards to the change of rule and that he has to report to the HR manager and they are on the same line. My experience is that most of the public sectors, the HR managers and the administrative managers are on the same rank when it comes to salary.
Okay.
They're on the same level when it comes to salary. But what that person should note is that the HR manager position is an appointment. And by virtue of his appointment, he has some supervisory role over other administrative managers, though you are taking the same salary. But by virtue that he has been appointed as the HR manager, he has that supervisory role. For that matter, if you are reporting to the person, you are not reporting to him or her based that you are on the same rank and you are reporting to him, but you are reporting to the position as the HR manager. So that's some explanation that I wanted to provide.
Right. Thank you very much, Simon, for that explanation. Okay, Sewa, you can unmute and ask your question, then I'll come to the chat and take Emmanuel's question. Sewa,
okay,
please go ahead.
Yeah, good afternoon, everybody. Senor, on the talking about suspension, mentioned that during suspension is expected, I don't know if I got it right, but then it's expected that you are coaching the person, giving the person who is on suspension some form of training or coaching. I don't know if I got it right. And if I got it right, I'll need more explanation on that. So for instance, this person has been suspended for an offense. Mm-hmm. And then whilst the person is on suspension, am I expected to be taking this person through a form of training to get the person better? Kindly throw more light on it for me. Thank you.
Thank you, Sewa.
Okay. So you see, suspension as a workplace, we call it an employee relations practice, came from somewhere. It came from the West. And the people who practice it best are the Americans. In the American system, suspension does not mean the person goes to sit at home and it does not work. Suspension means that the person is suspended from work, from their actual duty, but they have to undergo certain interventions, okay? So those interventions are supposed to correct the bad behavior before the person is reintroduced to their mainstream duties. That is what suspension was about. But somehow when we took it in our system, we wanted, as the kind of people we are, we always try to have our, there's slave master mentality. So we have to find a way of punishing the person. So even in suspension, instead of doing the mitigation of correcting the person, we decided that the person must go and sit at home. Then the question, if the person goes to sit at home and the person does not work, why should the person be paid? It is the wrong applications that brought us here. Somehow, the ILO conventions, okay, the world practitioners of labor, who we borrowed this principle from, where we say that an employee's pay cannot be touched, okay? An employee cannot be given any pecuniary penalty unless that which is permitted by law to protect the employee's remuneration. It is a global practice from the UN, from ILO, and that is what we have adopted. Somehow still, HR people, employers want to insist that when the person has committed an offense and you suspend the person must feel it. The person must be punished. and so you cannot pay the person. Well, the practice is there, and the law is there now. If nobody has really taken anybody on because they were suspended without pay, and that has not been tested yet. But the courts have ruled, a judge in the High Court has ruled that a person's pay is their property. So if the law says that you cannot touch it, you cannot touch it for any reason whatsoever, except. So the law has come. So what do? When people commit offenses, you apply sanctions. Those sanctions, if you want to choose, you have demotion or termination, but you want to choose suspension, then you've got to apply it well. You cannot suspend someone and retain the person's salary because it's not allowed. Okay, so if you want to suspend, then you know what you are doing. But of course, there are a lot of people who still have suspension without paying their policies, and they are going on and on. That's fine. One day when they are challenged, that is where we would know whether they did the right thing. But hey, good practice, just make sure that you penalize people properly for the offenses they commit. Yeah, and not
right. Thank you.
Yeah.
Thank you. So it means that it's a corrective measure. So you're supposed to make sure the person comes back better. So whatever intervention you need to put in place to ensure that the person comes back better, you do it. And I think that is what Senior is referring to. Thank you so much, Sewa, for that question.
Thank you so
thank
much.
you,
Thank you.
Okay.
Right.
Okay, Sewa.
I'll take Emmanuel's question before I come back to Samuel. Samuel, I see your hand. But let me, how do we treat an employee who has been on sick leave for several months? And can the employee seek for salary adjustment due to cost of living? I don't know whether Sonia will get this question.
Yeah, I get it.
Okay.
I've seen Sam's question too on constructive termination. I will answer the two of them together. You see,
all right.
Sick leave is not capped in Ghana. So, and sick leave is paid leave. Okay, sick leave is paid leave. So, where a person is sick for a long time, then you have to resolve that issue by policy. So a lot of companies have used policies to say that if the person is sick for 6 months, person will be on full salary. If the next 6 months, the person will be on half salary, and so on and so forth. Now, I've realized that most of those policies came from the 90s and the 80s. Okay, they don't meet current needs of the changing and growing organizations. When you have a bank who employed somebody to play a particular role in the treasury department, and the person falls sick for 6 months, and the person has not been to work, it means that the person's role has to be shared among other people to increase their duties, their workload, or now we are talking about organization design. So you have to share the person's role on their colleagues, increasing their workload or employing a new person. That is unreasonable. So I picked some good practices from New Zealand and Australia, where within reasonable time, say up to 3 months, if the employee is unable to come to work due to sickness, they are made to undergo a medical fitness examination, medical fitness for work exam. When they go through it, and within the next 3 months, they can recover and return to work, which will become a total of 6 months away, then they would be allowed to recuperate and come back. But if the medical exam shows that they are unable to return within the next 3 months, then a decision is taken of them to terminate their employment on the basis of sickness, okay, on the basis of ill health, which is a ground allowed at law. So for me, that is what I would do. 3 months, the person has not come. Let's give the person, and that's what people call the medical board. But anyway, the medical board is also a practice from the 80s, from the 70s and 80s. So what now is required is a fitness for work examination. when the person is medically checked for fitness for work, because remember, the law says that mandatorily, a permanent employer cannot be employed unless they have undergone medical fitness, which shows that they are fit to do the work they are supposed to do. That's the law, okay? So what then it means is that the person who is sick and hasn't come for 3 months, which is reasonable time away, should be made to undergo medical fitness for work for us to see whether truly the person is fit to work or not. If not, then we terminate the person and pay the person the necessary compensations that we are supposed to pay. Or if the person is going to recuperate, then we wait, then the person comes back. But I don't think that it's fair for an employer to be waiting for an employee for 1 year, paying the person's salary. And now we are being asked whether the person can even ask for salary adjustment. Of course, if the person is in the role and salaries have been increased, the person's salary will also increase. Is it fair to the employer? No. So the employer must take action to mitigate their losses in having to pay employees who claim to be sick or who are actually sick, for long periods, and try to end it at some point, because the law allows them to. Now, we went to do some work for a company some time ago, I think long ago, 10 years ago. And we went into the company and we realized the company was still paying employees who claimed to be on sick leave for 2 years, 2.5 years. And investigation showed that the employees were even working at other places. So they had new jobs at other places, but they had constantly said that they are sick in their current employer, and the employer keeps paying them. So if you go to bed, employees will really take advantage of the situation. So you need to enforce a very tight sick leave policy and make sure that you mitigate your losses accordingly. That is what I would advise.
Thank you very much. Let me pick some questions for you too, because I see some comment. YouTubers say we are not picking questions from there.
Oh,
okay, so Elisa.
Constructive termination. I said I'll do it. Basically,
okay,
it is where an employer structurally puts things in place for an employee to be frustrated in employment, what we call ill treatment. So they will ill treat you and force you to leave. And the law is saying that where you are ill treated, 63.3, where you are ill treated like that, or where the environment is made difficult for you to be able to work normally and be happy, when you can leave the job and then claim that you have been unfairly terminated under the circumstances, and that is a constructive termination or constructive dismissal. You terminate your own employment and go and file a claim against the employer that they have unfairly forced you to leave employment. And if you ask me, I have used this before and I won, okay? So I know that it works. So it is something that is tested and there's a ruling on it, okay? So that is what constructive termination then is. Okay, please go ahead, sorry.
That is very insightful, thank you. So Elizabeth on YouTube said, please, did you say suspension without pay is illegal? Yes, you did say that. Seyo?
Yes, yes, suspension without pay is not allowed. Read section 69 of the law. Yeah, 69, 1 and 2.
Okay. So Elizabeth, again, is there the need for staff to sign in acceptance of the policy? It will include deductions from their quarterly incentive. Okay, I think she's saying that the organization has introduced a rewards and penalty system as part of an employee recognition scheme. And this has been discussed extensively with the staff. Is there the need for staff to sign in acceptance of the policy? It will include deductions from their quarterly incentives. So it means that this has been discussed with the staff and they're okay, but he's asking if they should sign in, and would that be acceptable? would that be legal?
Can you just, I think you were breaking, so can you just summarize again the question?
Okay, so it says that is Elizabeth, that the organization has introduced a rewards and penalty system as part of an employee recognition scheme. This has been discussed extensively with the staff. Is there the need for staff to sign in acceptance of the policy? It will include deductions from their quarterly incentives.
Well, so incentives are not, incentives are conditional, like gifts, like bonus, okay? We have different aspects of remuneration, right? We have the statutory remuneration, which is the basic pay. Then we have the benefits, which are the allowances. Then we have the reward, right? So we have compensation, which normally would be the basic pay, you know, the statutory pay. Then we have the benefits. Then we have the reward. The reward is normally conditional. People don't reward for fun. And reward is not, rewards are earned. They are not entitlements. So if there's a policy, an incentive policy that attaches certain offenses and things like that to it, then it's perfectly lawful. In the bank, when I worked with the bank, one of the things I did was to tie discipline directly to reward, so that those who went through disciplinary, who were found culpable under the disciplinary policies in a year, would not get bonuses for that year. All rewards were cut off from them. So it became very expensive for an employee to even get a warning. Okay, so duties of an employer. The employer is supposed to provide and ensure the operation of an adequate procedure for the discipline of the workers. So discipline is the duty of an employer, and you need to put lawful disciplinary processes in place to make sure that your employees are controlled. That is one thing we do not know how to do in Ghana, and that is why we feel that Ghanaian employees are not good employees. They are lazy and they are this. Supervision is poor, and proper discipline structures are missing. So the employees do whatever they want. So then now you want to find your own way of punishing them and breaching the law. I wish you well. You can do it. Anybody can do anything. But when you are challenged, make sure that you are not found wanting, because if some of us come for you, you will have nowhere to hide.
And this is a follow-up to Love's, because he says, would it not be unfair to the employer to suspend the employee and still pay the employee?
But nobody is forcing you to suspend the employee. Nobody is forcing you to suspend the employee. You choose to suspend the employee. And we are saying that, you see, these things, economics will tell you that when the curve is downward, it means something. When the curve is upward, it means something. When your BP is up to a particular thing, medicine will tell you that it is critical. Okay. HR and employment relations, employment law is telling you that when you suspend, it is not for penalizing the employee, but correcting the employee. So if you want to use suspension to penalize the employee, then it is your own doing. When the law comes after you, that is not what is prescribed, because suspension means something in HR. Now, suspension does not mean that the employee is being punished. Nobody punishes an employee by just asking them to go and sit at home. And even if you do not pay the employee will come back. How are you sure the employee has changed? The employee only lost money. And we know money doesn't work. So, hey, let us look at the end game. What do we seek to achieve? If we want to penalize the employee and what the employee did is unacceptable, terminate the employee and let's stop hiding behind suspension without pay as if we are doing something. Oh, we cannot terminate him because we need him. If you need him, then correct him and change him and let him come to the table properly. If he cannot fit, cut him off. It's as simple as that. You see, but the law is clear. I mean, honestly, nobody can. Look, some lawyers have argued and argued and argued with me. The law is clear. And a judge has upheld it. So now we are fine. I'm so happy about this law. I started teaching this thing in 2009. How many years ago? You know? Yeah. Okay.
Thank you. So I think sometimes we are afraid to terminate because maybe the employee can take us on and all that. But it means that before you terminate, you make sure that you take the employee through the process and leave an audit trail so that if you are challenged, you have the evidence to support that. Thank you. We have 2 minutes, then we release Senor, okay, no matter what. So Senor, maybe the last question I'm asking, and then you can give your final word. And don't forget, Senor will be having a master law, labor law masterclass. Was it something? I think you mentioned something like that. Maybe before you go, you can talk about it so that they can really register and come and pay and take and get all the knowledge. So Adam is asking, can an employee on a leave without pay legally resign within that leave?
Yes, an employee can resign at any time. An employer can do FOCO. The only thing an employer can do is to insist on a proper handing over process and so on and so forth. That is why for me, when employees are even going on leave, you need to make sure that they properly hand over. Because where you don't do that, and during leave, the employee resigns, it becomes very difficult to get the employee to come in and hand over properly and so on and so forth. We need to put policies in place that make sure that we are in control of our organization and no single employee can hold us hostage, you know. So where an employee, because an employee, forced labor, I've talked about it, you cannot stop an employee from resigning, except maybe the employee is before a disciplinary committee or something. But even that one, you can only say that let us finish and then you have to be available to participate in the disciplinary processes. So you cannot resign. But otherwise, an employee can always resign. It is their right, it is their choice. And so that's it. We need to prepare for it. Nobody can prevent an employee from resigning at any time. Yes.
Thank you very much, Senor. We'll give your final word. But before that, Gerald, I see your question, but Senor will leave his contact. Then please contact him so that he can help you with the question, because I think you have a peculiar issue you are dealing with. Senor will be able to help you. So, Senor, if you can give us your final word and then your phone number so they can reach you for the questions that we have not been able. And you can talk about the labor law masterclass as well. Thank you.
Okay. Okay. So let me just say that, first of all, thank everybody for joining. This really means a lot to me because we always find people, really getting into trouble when it comes to, some of these problems. Now, what I want to say finally, therefore, is that let us just make sure that when it comes to termination, we have our policies properly outlined, properly put in place, and then we follow them. For every termination or dismissal decision, let's use the disciplinary process, the disciplinary committee, hearing the person and making sure that the person is actually culpable of whatever we've accused them for. We can terminate arbitrarily, but when we are challenged, we will have to prove that we were fair. Sometimes we can defend our arbitral action. Sometimes we cannot. But the best way of ensuring that we don't pay compensation, a lot of money for that matter, is that we make sure that we leave the necessary documentation behind us, knowing that we have followed our processes and procedures, and we have lawfully terminated people who, when they take us on, we can hold our own and we can defend our organization. HR people are costing a lot of companies money. And I've always said it, now I'm in an executive position. If my HR costs me money, I'm firing him. If he takes a decision that ends up making me pay compensation, I'm firing him. Because when operations people, cost us money and we fire them, so why shouldn't an HR person be fired if they take the wrong decision? We need to understand these things and be sure that we are there for the company. Now, if we do our part and a very stubborn CEO or MD still insists on terminating or doing the wrong thing, make sure that you are covered, that it is on record that you advised, but it wasn't taken. Your professional career will speak for you, but let us not be the ones doing the wrong thing. My number is 0244-792728, 0244-792728. I'm trying to put it into the chat window, but it looks like it's not coming. But it's 0244.
Say it again and let me put it there. 0244
792728.
792728.
Yes, 28. And it comes to WhatsApp. So thank you guys for all of that. We are thinking about doing a seminar on the new labor bill. There's a new labor bill 2024 that is gone to Parliament, that is going to be debated and possibly passed before the end of the term of this government, or possibly if it goes into the next government, then it will happen. But it is a law that is more expansive, it's more detailed, and it is now covering a lot of other areas like paternity leave and all other areas. So we are thinking about doing a seminar on that, but I'm still thinking about it. If we do run it, definitely we will all get to know, and then we can all participate so that we can have something, cogent that we can contribute to Parliament when the subcommittee is debating it. So thanks for everything, and thanks for having me, Patricia.
Thank you so much, Senor. Thank you for always being available for us. We are grateful. Thank you, everyone, for joining us. I will see you again this time on StreamYard next week with another interesting discussion. But please, if you've not yet registered for our compensation and benefits management training, please click on the link and register. It's very practical, it's hands-on. You'll be able to do a proper job evaluation, and based on that, build your own salary structure, scheme of service that is very fair, both internally and externally. Thank you, everyone. Do enjoy your week. even as the week starts today. Thank you. See you again. Thank you, Senor. God bless you and your household for always